Has expired.
Thanks, Senator Whitehouse. Senator Grassley.
Thank you, Mr. Chairman. Thanks to the witnesses before us. The framers of the Constitution carefully crafted a system of checks and balances. While the Constitution purposefully insulated the federal judiciary from political control, it's important that Congress exercise constitutional duty of oversight. Judges are expected to comply with high standards of ethics and integrity, and it does appear there needs to be better oversight. I've been a longtime advocate for transparency and accountability because I believe the public's business should be public. I've been a strong proponent of government oversight and the duty of Congress to be good stewards of the taxpayers' dollars. I've endeavored to improve our government and promote greater responsibility at all levels. I've worked on bills to root out waste, fraud, and abuse and to foster integrity and accountability, including in the federal judiciary. Unfortunately, Democrats and their left-wing dark money interest groups, as well as their allies in the liberal media, have engaged in a crusade to threaten, pack, and smear the courts. They've targeted specific judges and justices who aren't implementing a liberal agenda that they can't ram through Congress. The goal of these efforts is to cast doubts on certain judges and justices, all because the left is opposed to recent court rulings. That's what this hearing is all about, undermining the American people's trust in our judicial branch of government. Today's hearing is just one political theater to delegitimize our judicial system, particularly the Supreme Court. Judicial decision-making must be based on law and sound jurisprudence. It must not be subject to the whims of public opinion and clamor. It must not result in threats and intimidation. As this relentless political battering of certain members of the judiciary who aren't doing the bidding of the liberal grand plan is coming at a tremendous cost. Our judges and justices face harassment and public intimidation in their private life, despite federal law, which prohibits picketing or parading at a judge's residence. Our justices and their families often endure organized protests outside their homes. Judges and justices and their families face real threats to their safety and security. Unfortunately, the whirlwind that Democrats threaten at the steps of the U.S. Supreme Court really has been released against our judiciary. So I'm going to ask Mr. Dupree and Judge McKaysey two separate questions. The first one is for Mr. Dupree. Federal judges are required by law and the Judicial Conference to comply with these disclosures and ethical guidelines. Can you please give us a brief overview of the constitutional framework in which these rules and guidance operates? And then for Judge McKaysey, this question: how is the Supreme Court different than the lower courts with respect to complying with these rules? Mr. Dupree.
Sure. Well, thank you for the question, Senator Grassley. There are, of course, a number of statutes that affect the information that Supreme Court justices must disclose, and also governs things such as recusal and disqualification. In some circumstances, the statutes act directly upon the justices themselves. I think in those cases, they would concern what I think all of us would consider non-core Article III duties, and that's why, as a constitutional matter, it would be permissible for Congress to directly regulate the judiciary in that respect. There are other statutes where what Congress has done is created the Judicial Conference, which sets effectively regulations for the majority of the federal judiciary, but is not directly controlling upon the Supreme Court. Nonetheless, the Supreme Court, really as an exercise of discretion, has agreed to follow and respect and comply with those types of guidelines. So I think that constitutionally speaking, that Congress, or excuse me, the Supreme Court would be regulated in two ways. One is through direct regulation when it concerns a non-core Article III activity, and the other would be in indirect regulation where Congress directly regulates the lower courts, but the Supreme Court justices voluntarily agree to abide by and comply with those requirements.
Judge McKeezy.
Well, I agree with Mr. Dupree's portrayal of the way the system works. As to the mechanics, I think that the rules of general application that apply to all courts are applied to judges and justices. And and as was pointed out before, it's sort of an iterative process. You file your report, you file your form, and they get back to you. Those who review the form and ask for greater detail when necessary. And generally it's provided. I think the one feature that was alluded to before about the Attorney General making a determination of willfulness, I don't know that that's ever been litigated. And if it were ever litigated as to a Supreme Court justice, I believe it would be found to be unconstitutional. That is not anything that I believe has ever been tested, certainly not on the Supreme Court level.
Thanks, Senator Grassley. Senator Klobuchar.